The kitchen smelled like warm coffee when my phone rang that Tuesday morning. I almost didn't answer. I was already running late, and my brain was still working through the day ahead. But when I saw the caller ID, Crestview Academy Finance Office, I picked up without hesitation. The voice on the other end was careful and soft. The kind people use when they have to deliver news they would rather not say out loud. The woman introduced herself as the school's finance coordinator. Then she paused before going on. She told me that my son Eli's tuition account had an unpaid balance that had been building for several months. 3 written notices had gone out. None had received any response. The school was preparing to suspend his enrollment within 3 days if the situation didn't change. My chest tightened before she even finished the sentence. Then she said the part that made everything stop. Your ex-husband contacted our office last week, Mrs. Dalton. He informed us that he will no longer be responsible for your son's tuition going forward. I set my coffee mug down slowly on the counter. Calvin had actually done it. After months of late payments and sharp little text messages designed to make me nervous, he had finally made his move. He believed cutting off tuition would send me into a panic. He thought I would call him, scared and desperate, and give him whatever he wanted just to keep Eli in that school. My name is Rebecca Dalton. For 15 years, I was the person who held our family together. And that phone call was the moment I realized Calvin had just made his very first serious mistake. Because the enrollment account he was trying to destroy had something inside it he had never once taken the time to read. People who met Calvin Hartley usually liked him right away. He was charming in that easy, natural way that fills a room without effort. He knew exactly what to say at dinner parties. He told great stories about properties he was closing and trips he was planning. He had a gift for looking successful. What most people never saw was what happened once the door closed. Calvin loved the idea of achievement far more than the work it required. He was happy to enjoy the results as long as someone else managed the details. And for 15 years, that someone was me. My name is Rebecca Dalton, and I worked as a senior administrative coordinator at a large outpatient medical center. My entire career was built around contracts, compliance systems, financial paperwork, and schedules. I was trained to notice what others missed. I caught problems before they became crises. That skill didn't stay at the office, it came home with me every single evening. During our marriage, I handled everything. Tax filings, mortgage paperwork, insurance renewals, education savings accounts. And when Eli was 6 years old and we decided to apply to Crestview Academy, I handled every part of that process too. The application took 8 full months of careful preparation. I tracked every deadline. I completed every form. I organized every supporting document and followed up with every contact. Calvin showed up for the acceptance photograph. He never once read the actual enrollment agreements behind it. Not a single page. The divorce hearing took place on a cold Thursday morning in February, 2 years before that phone call from the school. The courtroom was quiet and formal, and Calvin walked in wearing his best dark suit. He always dressed carefully when people were watching. When the subject of Eli's tuition came up, Calvin straightened in his chair. The judge asked directly how the private school fees would be handled going forward. Without pausing to think, Calvin said he would cover the full tuition every semester, without exception. He said it like a man making a generous announcement. His attorney gave a small, satisfied nod. The judge approved the agreement. It looked responsible. It sounded generous. And nobody in that courtroom questioned it very hard. What nobody paid close attention to, not Calvin, and not even his own attorney, was a small clause I had added during the mediation stage weeks before the hearing. It addressed tuition account management and enrollment authority. It stated that both parents held equal rights over enrollment decisions, and that any tuition-related financial failure could trigger a formal review of the full court order. Calvin barely glanced at the page before signing his name. I remember watching him write that signature and thinking how strange it was. Here was a man who loved control so deeply. And yet he couldn't be bothered to read the very document that would define the terms of his life going forward. That clause, I thought quietly, might matter one day. I had no idea just how right I was. For the first few months after the divorce, Calvin paid tuition on time. Not because he wanted to. I could feel the difference even in the timing of the payments. He paid because the judge was still watching and he needed to perform the role of devoted father just a little longer. But people always show you who they really are when the spotlight moves. By the end of that first year, payments began arriving late. A week behind. Then 2. I would receive a notification from the school and have to send Calvin a reminder. He would respond with something vague and unbothered, as if doing me a favor just by answering. Then came the text messages. Private school isn't cheap, Rebecca. Maybe it's time you started contributing more. I've been carrying this arrangement alone. That wasn't the deal. If things don't get more balanced between us, I'm going to have to rethink this. I read every message carefully. I saved every single one of them. Because I understood exactly what he was doing. Calvin wasn't running short on money. He had recently received a promotion at his real estate firm. He had moved into a newer apartment downtown. He was driving a leased car he hadn't mentioned to anyone. He wasn't struggling financially. He was negotiating. He was using Eli's education as a pressure point, trying to push me into giving up ground in our custody arrangement. I understood that clearly. And I decided right then that I needed to be ready for whatever he tried next. A few months before the finance coordinator called me, I had a quiet conversation with Ms. Webb, the registrar at Crestview Academy. I didn't arrive with complaints or alarm. I simply came with paperwork and a calm, reasonable question. I explained that I was the parent who handled all the administrative details connected to Eli's account. I told her I wanted to make sure a formal process was in place so that no changes to his enrollment status could occur without both legal guardians being notified first. Ms. Webb told me this was a standard option the school offered for families with shared custody agreements. She referred to it as a parental enrollment protection notice. Once it was filed on an account, any attempt to suspend, withdraw, or significantly alter a student's enrollment had to pass through a documented review process. Both parents would be notified. The existing court agreement would be formally referenced. It was completely routine. It was entirely legal. And it required no conflict to put in place. I signed the form, kept my own copy, and drove home. I didn't tell Calvin about it. There was no reason to. It wasn't a trap or a secret weapon. It was simply a safeguard, the kind of careful step any thorough parent would take. But when the phone call from the school came months later, I opened my email and pulled up the confirmation notice Ms. Webb had sent me after our meeting. It was right there. Patient and waiting. Just the way careful things always are. Calvin's text arrived on a Wednesday afternoon, 3 days after the school's phone call. I was at my desk reviewing a compliance report when my phone buzzed on the desktop beside me. I picked it up and read the message. Since you're so capable of handling everything, you can handle tuition now. I'm done. Figure it out. That was it. No explanation. No mention of Eli by name. No regret. Just a statement dropped like a coin into a drain. In his mind, the message was a finishing move. He had cut off the money, and now I would come running. I would call him, upset and scrambling, and he would suddenly have all the power. He would use that moment to push me toward whatever schedule change or custody shift he had been working toward for months. I set the phone face down on my desk and finished the paragraph I had been reading before it buzzed. Then I picked it up again, typed 2 letters, and pressed send. Noted. That was all. Later that evening, I imagined him reading that word and feeling confused. He had expected something long. Something emotional. A call full of questions and fear. Instead, he had received a period at the end of a sentence. I wasn't panicking. I wasn't scrambling. I was already planning 3 steps forward while he was still celebrating what he thought was a victory. 2 days after Calvin's text, I drove to Crestview Academy and asked to meet with Ms. Webb privately. I brought my folder with me, the one holding the court order, the full tuition agreement, and the printed confirmation of the enrollment protection notice. Ms. Webb welcomed me into her office and closed the door. I laid everything out in front of her, calmly and in order. I explained that Calvin had formally withdrawn his commitment to pay. I showed her the text message. I showed her the court order that stated, in plain language, that he was the legally designated party responsible for tuition. Her expression shifted quietly as she read through it. I asked her to follow the enrollment protection process exactly as we had set it up. I wasn't asking the school to ignore the unpaid balance. I fully understood that Crestview Academy had its own responsibilities to manage. But I needed every step in the process to be properly documented. Because when a parent chose to ignore a court-ordered financial obligation, those documents didn't just live in a filing cabinet. They became evidence. Ms. Webb nodded. She picked up her phone and placed a brief call to the school's administrative director. After a short conversation, she turned back to me. "We'll process this through the full protection review," she said. "Everything will be on record." I thanked her and shook her hand. The process was now moving. Quietly, correctly, with documentation at every turn. Calvin had no idea. That weekend, I sat down at my kitchen table with a legal pad and began building a timeline. I pulled up every bank notification I had saved from the past 18 months. Every transfer record. Every school invoice and payment confirmation. I printed Calvin's text messages, including the ones where he suggested tuition was too expensive and implied he might stop paying unless I made concessions. I arranged everything by date and labeled each item clearly. Then I opened the court order from the divorce and highlighted the tuition clause in yellow. I noted the exact language. Calvin was solely responsible for Eli's full tuition at Crestview Academy for as long as Eli remained enrolled, unless both parents agreed in writing to a different arrangement. No such agreement existed. No document to that effect had ever been created. I also pulled out the enrollment protection notice and the email from Ms. Webb confirming it had been properly filed. By the time I finished that evening, the kitchen table was covered in neat stacks. Every missed payment had a date. Every text message had a timestamp. Every school notice had a reference number. I gathered it all and placed it inside a large manila folder. Then I took a black marker and wrote 3 words on the front. Hartley Tuition Agreement. I set the folder on the corner of my desk where I would see it every single morning. The work of a careful person never looks dramatic. It just looks like a folder. But that folder was ready to speak in a place where words carry the most weight. A colleague of mine who worked in the same professional circles as Calvin mentioned something during a casual conversation about weekend plans. She had seen Calvin at a restaurant the previous week, one of those places with dim lighting and heavy menus. He wasn't alone. I did some quiet, simple research after that. Nothing complicated. Just the kind of natural observation that happens in a mid-sized city where professional networks overlap. Within a few days, I had a clear enough picture. Calvin had a new girlfriend. Younger, well-presented, with a life that photographed well. He had also relocated to a luxury apartment in the River District, the kind of building with a rooftop terrace and a uniformed concierge. And according to someone who worked near his firm, he had recently leased a dark blue sports car that people in the office parking lot noticed regularly. None of this was hidden. He wasn't even trying to be discreet about any of it. He wasn't a man facing financial hardship. He wasn't a man making difficult sacrifices. He was a man spending freely on a new life while deliberately ignoring a legal obligation to his own child's education. I thought about that carefully as I looked at the Hartley Tuition Agreement folder sitting in the corner of my desk. A family court judge, I knew, would think about it carefully too. And unlike me, a judge had the full power of the court to act on what they found. 2 weeks after my meeting with Ms. Webb, the Academy sent out its formal delinquency notice. Because of the enrollment protection notice I had placed on Eli's account, the document didn't go only to Calvin. It was sent to both of us simultaneously, with full supporting documentation attached. The notice confirmed the total outstanding balance, listed each missed payment with its exact due date, and explained that multiple attempts had been made to contact the responsible party without any resolution. It was a formal document, the kind that gets filed in records and referenced in legal proceedings. I received my copy and saved it the moment it arrived. Calvin received his copy too. I know this because within 40 minutes, my phone began ringing. I watched his name appear on the screen. I let it ring. He called again. I let that one go as well. That evening, I listened to both voicemails. In the first, his voice was sharp and irritated, the tone of a man who expected his call to be answered. In the second, underneath the irritation, there was something different. A tighter quality. Closer to alarm. He had assumed the school would quietly suspend Eli and push the full pressure onto me. He had not anticipated a formal notice arriving at his address, one that named him specifically as the court-designated responsible party who had failed to meet his legal obligation. The documentation had surprised him. That had been exactly the point. Calvin called again the next morning. This time, I answered. He skipped any greeting. He went straight into it, his voice tight and controlled, like a man holding a door closed against something trying to push through. Rebecca, what is going on? Why is the school sending formal notices to me? You need to fix this. I let him finish. I didn't interrupt. I waited until I was certain he had said everything he intended to say. Then I responded, calmly and clearly. Calvin, you are the party designated as responsible for tuition under our court order. The school is notifying you because that obligation is yours, not mine. He said the order was outdated. He said things had changed. He said that if I truly cared about Eli's well-being, I would step up and help instead of making everything difficult. I listened to all of it without raising my voice. You signed that agreement in front of a judge, I said when he finished. If you believe the order needs to be modified, you have the right to file a motion with the court. There was a pause. I could hear him breathing. Don't push me on this, Rebecca. I'm not pushing anyone, I said quietly. I'm simply reminding you of what you agreed to. He hung up. I sat for a moment in the quiet that followed. Then I wrote down the date, the time, and a brief, factual summary of everything that had been said. I slid the page into the folder. I called my attorney, Ms. Reeves, the following week. She had handled my divorce from start to finish and knew every detail of the case. When I walked her through what had happened, the stopped payments, the text messages, the school's formal delinquency notice, and Calvin's phone call, she was quiet for a moment before speaking. He violated a direct court order, she said. That's not a gray area, Rebecca. She told me the right move was to file a tuition enforcement motion in family court. This would bring the matter formally before a judge and ask the court to compel Calvin to pay the outstanding balance, along with late penalties and legal fees as specified in the original agreement. I told her I was ready to move forward. Ms. Reeves spent the following days preparing the filing. We included the full payment history showing every missed installment. We attached the court order with the tuition clause clearly highlighted. We included Calvin's text messages, especially the ones implying he might stop paying if I didn't cooperate. We included the school's formal delinquency notice and Ms. Webb's documentation from the Enrollment Protection Review. The filing was thorough. Every page told part of a complete, consistent story. On a Friday morning, I drove to the courthouse and watched the clerk stamp the document with the official date and time. The case number was assigned on the spot. It had officially and formally begun. After the court filing was submitted, something shifted at Crestview Academy that I hadn't fully anticipated. Once the school's administrative team understood that Eli's account was now tied to an active family court enforcement motion, they escalated the situation through their own internal channels. Ms. Webb forwarded the full account file to the school's legal office. The legal team reviewed the enrollment protection notice, the unpaid balance record, and the documented communications showing Calvin's clear refusal to pay. What they identified was that the school itself carried a potential responsibility. If a student experienced educational harm due to a payment dispute that was connected to a court-ordered agreement, and the school had not followed proper protective procedures, questions could arise about how the matter had been managed. Because I had placed the enrollment protection notice on the account months before the dispute began, the school could demonstrate they had acted correctly at every stage. Their documentation was clean and thorough. Calvin had no such protection. His name sat at the center of a growing paper trail, one that directly connected his voluntary decision to stop paying tuition to a student's potential disruption in schooling. The Academy's legal office began preparing a formal written account of the situation. It outlined what had been communicated, when, by whom, and what responses had been received or not received. It was another piece of solid evidence. One I hadn't even needed to ask for. Calvin's professional life had always been built on reputation. He worked as a senior agent at a regional real estate development firm that sold high-end properties to clients who cared deeply about the character of the people they worked with. In that industry, trust wasn't just a bonus, it was the product. And a man who couldn't honor his word on something as basic as his own child's education did not make the strongest impression on the kind of clients who paid attention. Word traveled in ways Calvin had probably not considered when he sent that two-sentence text message. One of the school's board members happened to be professionally connected to a partner at Calvin's firm. Nothing formal passed between them. No announcements were made. But in the quiet world of professional relationships, the fact that Calvin Hartley was involved in a court matter regarding unpaid child education costs began filtering through conversations. A client who had been close to signing an agreement with Calvin reportedly asked another agent about the situation. The other agent had no specific details to offer. But the question alone was enough to create hesitation. Calvin's image as the sharp, dependable professional began to show its first small crack. He had spent years building that image carefully. The right suit. The right car. The right words at the right events. And now, because of a choice he had made to stop paying for his son's schooling, that carefully built image was beginning to come apart at the edges. Another month passed. Another tuition deadline arrived and went by without a payment. Calvin did not respond to any of the notices from the school. He did not contact Ms. Reeves. He did not reach out to me. The outstanding balance on Eli's account doubled. Each passing week added another layer to the documentation that Ms. Webb's office was building. Every invoice. Every reminder sent to the correct address. Every formal notice with Calvin's name listed as the legally responsible party who had not responded. I kept my own records updated in parallel. Ms. Reeves had instructed me to log every piece of communication and every missed deadline clearly and by date. I followed that instruction without fail. What was interesting was how quiet Calvin had become. After that phone call where he told me not to push him, I had heard nothing directly from him. No texts. No calls. No messages passed through any shared contacts. I didn't know whether that silence meant he was planning something, or simply sitting with the growing discomfort of what he had set in motion. But his silence didn't change a single fact in the record. Every day he failed to pay was another day the timeline against him grew longer and more complete. I thought sometimes about what he must have imagined when he sent me that short, dismissive text. He had probably pictured me panicked and undone. Instead, I was at my kitchen table every evening, updating a folder that was getting thicker by the week. Around the time the second payment deadline passed without response, Ms. Webb reached out to me with an update I hadn't expected. The Academy had prepared a formal written statement from the registrar's office. It was an internal document, but she told me it had been flagged as directly relevant to the family court matter my attorney had initiated. The statement outlined the full sequence of events from the school's perspective, organized by date and supported by their own internal records. It confirmed that I had proactively contacted the school and placed the enrollment protection notice on Eli's account months before the payment dispute ever began. It confirmed that I had cooperated fully throughout the entire process and had responded to every communication from the Academy without delay. It also confirmed that Calvin had contacted the school directly to state he would no longer be paying, and that no alternative arrangement had been proposed, discussed, or documented by him at any point. Ms. Webb told me that if the court requested a statement from the school, this document would serve as their official submission. I thanked her and asked her to send a copy to Ms. Reeves directly. She did so that same afternoon. That evening, my attorney called after reviewing it. Her voice carried the kind of quiet professional satisfaction I had learned to recognize over our years of working together. "Rebecca," she said, "he gave us everything we needed. The school's record alone tells the whole story." I agreed. It did. Calvin hired an attorney in the third week of the following month. Ms. Reeves received formal notification that Calvin was now represented by a lawyer named Mr. Osei from a well-established family law firm. The letter was professionally worded and indicated that Mr. Osei's team would be reviewing the enforcement motion and preparing a formal response in the coming weeks. Ms. Reeves called me after reading it. "Good," she said simply. "That means he's finally taking this seriously." But what she told me next was the part that mattered most. Based on her reading of the situation, she believed Calvin's attorney had almost certainly reviewed the court order very carefully by now, and had likely given Calvin an honest, direct assessment of where he stood. Ignoring a judge-approved tuition order was not a minor oversight. It was a clear violation of a court order. In family court, that kind of violation was treated with real gravity. It reflected not just on a person's finances, but on their reliability and their judgment as a parent. Those were two things a family court judge weighed very carefully. Mr. Osei, she told me, had a reputation as a thorough and competent attorney, which meant he would have told Calvin the truth, in precise professional language, about how seriously the court was likely to view what he had done. I thought about Calvin sitting across a desk from a lawyer who was explaining, carefully and clearly, that his plan had not gone the way he expected. Something settled quietly in my chest when I pictured that conversation. A few days after we received notice of Calvin's new legal representation, Mr. Osei's office sent a formal request for discovery documents. Standard procedure in family court matters. They wanted to review the full record, payment histories, the original court order, and all school-related communications. We sent everything. Every document in the Hartley tuition agreement folder. Every page. What happened next I heard about through Ms. Reeves, who had spoken briefly with Mr. Osei's office regarding the hearing schedule. When Calvin's legal team reviewed the enrollment protection notice I had placed on Eli's account, the one filed months before any payment dispute began, they had to stop and reread it. And when they located the clause I had added during divorce mediation, the one addressing tuition account management and enrollment authority, things became very clear very quickly. The clause stated that if the court-designated paying parent failed to meet tuition obligations, the other parent had the right to request a formal financial review. That review could result in the court examining the responsible parent's full financial picture, income, assets, and spending patterns, to determine whether the failure to pay reflected genuine hardship or deliberate avoidance. Given what Calvin had been spending money on during the same months he refused to pay tuition, that review would not be kind to him. Mr. Osei contacted Ms. Reeves shortly after discovering the clause. According to Ms. Reeves, his message was brief and to the point. We were not aware this language existed. Calvin had signed a document he never read, and it was about to cost him considerably more than tuition. The Academy's governing board held its quarterly review during this period. Crestview Academy was a long-established institution with a carefully protected reputation. The board took that reputation seriously, perhaps more seriously than anything else connected to the school's identity. During the review session, the tuition dispute connected to Eli's account was raised as a matter requiring board awareness. Not because the school was eager to involve itself in a family legal matter, but because the account was now formally connected to active court proceedings. The board needed to understand the school's exposure and confirm that every step had been handled correctly. When they examined the record, they found exactly that. The enrollment protection notice had been placed on the account correctly and documented properly. Formal notices had been issued in full compliance with the school's established procedures. Every communication had been logged and time-stamped. The school had acted with complete professionalism throughout. But Calvin's name appeared repeatedly throughout that documentation. Always as the party who had been contacted, who had responded with a clear refusal, and who had made no attempt to resolve the matter through any channel. Board members asked measured questions, the kind that come from people who understand that a school's reputation is tied closely to the conduct of its community. Calvin Hartley had been a name connected to Crestview Academy for years. His son was enrolled on a strong academic record. Now his name was appearing in a board meeting for an entirely different reason. I heard about the workplace incident through a mutual acquaintance who moved in the same professional real estate circles as Calvin. She called me one evening, not to gossip, but because she genuinely thought I should be aware of what had happened. She explained that she had been present at a property showing the previous week, a new luxury townhome development that Calvin's firm was actively marketing. A well-connected local developer had been touring the property with Calvin as the showing agent. At some point during the tour, the developer had asked Calvin a direct question. Someone in their shared social network had apparently mentioned the ongoing court situation. The developer wanted to know whether what he had heard was accurate, whether Calvin was genuinely involved in a legal dispute over unpaid school fees for his own child. Calvin had attempted to redirect the conversation. He said it was a misunderstanding that was being handled privately. But the developer had gone quiet for the remainder of the showing and left without making any kind of commitment. Calvin's colleague, who had been nearby for part of the exchange, told her that Calvin's mood for the rest of that afternoon had been noticeably dark. I didn't call Calvin. I didn't reach out to anyone about what I had heard. I didn't share it with anyone who might pass it along. I simply picked up my pen, noted the date quietly in my log, and placed the information in the back of my mind where careful people keep things they don't yet need but know they will. The letter from family court arrived on a Thursday morning. The enforcement hearing had been officially scheduled. The date was 6 weeks away. The courtroom assignment was listed near the bottom of the page, along with the case reference number. Ms. Reeves called me within the hour after receiving her own copy. She walked me through what to expect on the day. The hearing would give both parties the opportunity to present their positions directly to the judge. Calvin's attorney would likely argue that the tuition obligation needed to be adjusted or shared between both parents. Our job was to show clearly and factually, using the documented record, that Calvin had deliberately violated a direct court order, not because of genuine financial hardship, but by choice. I asked Ms. Reeves how she felt about where the case stood. She was quiet for just a moment before she responded. Rebecca, I've handled family court matters for a long time. I've seen cases with far less documentation than what you've built fall in the right direction. You didn't just keep records, you kept the right records, at the right time, in the right order. The story your folder tells is clean, complete, and impossible to argue around. She told me to continue doing exactly what I had been doing, going to work every day, caring for Eli, living steadily, and letting the evidence carry the weight. I closed the letter, placed it carefully in the folder, and started dinner. 6 weeks felt very close now. The 6 weeks between the hearing notice and the actual date moved slowly at first and then very quickly. Ms. Reeves and I met twice during that period to organize everything into a clear, structured presentation for the judge. She was methodical about it, exactly the way I preferred to work. We arranged every piece of evidence in strict chronological order, building a sequence of events that any reasonable person could follow without confusion. The text messages came first. They showed Calvin's attitude toward the tuition obligation long before he stopped paying. They documented a pattern, not a single moment of financial stress, but a slow and deliberate campaign designed to use our son's schooling as leverage. Next came the payment records. Each missed deadline dated precisely. The growing outstanding balance. The school's formal notices sent to his registered address. Then came Calvin's direct communication to the school stating he would no longer be paying, written in his own words, submitted voluntarily to the Academy's finance office. After that, the enrollment protection notice, filed months before any of the dispute began, showing that I had anticipated the possibility and taken proper legal steps to protect Eli's enrollment in advance. Then the registrar's formal statement confirming what the school had observed and documented throughout. And finally, the clause from the divorce mediation agreement, the one that opened the door to a comprehensive financial review if tuition obligations were deliberately ignored. Laid out in order, it didn't look like a disagreement between two people. It looked exactly like what it was. The morning of the hearing, I dressed simply. A navy blazer, dark slacks, plain shoes. I was at Ms. Reeves's office by 8:15. We drove to the courthouse together, and she walked me through the likely order of the session one final time. When we entered the courtroom, Calvin was already seated at the opposite table. He wore a gray suit. From a distance he appeared composed, but I had known that man for long enough to read the tension in the way he held his jaw and the way his eyes moved when I walked through the door. Mr. Osei sat close beside him, reviewing documents. The judge entered and the room came to order. She moved through the opening procedures efficiently. Then she invited both attorneys to present. Ms. Reeves laid out our case in clean, unhurried language. She didn't dramatize anything. She didn't need to. Every fact she placed in front of the judge was supported by a dated, documented piece of evidence. The story told itself. Mr. Osei argued that the financial demands of the tuition arrangement had become unreasonable, and that the obligation should be reconsidered and shared between both parents. He spoke about changed circumstances. He worked hard to make the situation sound complicated and uncertain. The judge listened to both sides fully. Then she asked for the documentation. Ms. Reeves stepped forward and placed the folder on the bench. The judge began reading. The room went completely still. Calvin sat without moving. The longer the silence lasted, the more of the air seemed to leave his side of the room entirely. Then the judge looked up and turned directly to face him, setting the folder down with a kind of deliberate, unhurried stillness that made the entire courtroom hold its breath. She looked at Calvin steadily for a long moment before she spoke. She began by noting that the record before her was clear and complete. The court order had been signed and approved following a hearing where Calvin had personally and voluntarily offered to cover full tuition. The obligation had not been assigned to him or negotiated downward or reluctantly accepted. He had presented it himself, in open court, as a demonstration of his commitment as a parent. Then she read the clause aloud, the one from the mediation agreement that Calvin had signed without reading. The one about tuition account management, enrollment authority, and the financial review that failure to pay could trigger. She noted that the non-payment had not been the result of any documented financial hardship. The evidence demonstrated a deliberate withdrawal of payment, supported by the defendant's own text messages, his direct written communication to the school, and his known personal spending during the identical period when tuition went unpaid. She also acknowledged the enrollment protection notice and what it demonstrated about the plaintiff's conduct throughout the entire situation. The ruling came clearly and without hesitation. Calvin was ordered to pay the full outstanding tuition balance immediately. He was ordered to cover the full legal fees I had incurred pursuing the enforcement motion. He was ordered to pay late penalty charges as specified in the original agreement. Then the judge added one final statement, delivered quietly, without drama, but with full weight behind it. Any future violation of this court order would be treated as a direct matter for custody review. The months that followed settled into a kind of quiet I hadn't felt in years. Eli walked through the doors of Crestview Academy every morning the same way he always had, backpack on his shoulders, headphones around his neck, looking exactly like a boy who had no idea how close his future had come to being disrupted by the choices of someone who was supposed to protect him. I was glad he didn't know. Children should be allowed to move forward without carrying the weight of adult battles on their shoulders. Calvin kept the payments current after the ruling. Not because something deep had changed in him, but because the judge's final warning about custody review had made the cost of another misstep very clear. Some people grow and change because they reflect on their choices. Others change because the consequences finally speak in language they can't ignore. I had stopped trying to determine which kind Calvin was. What I thought about instead was that folder. That thick manila folder I had built one careful document at a time, over the course of many months, while Calvin sat somewhere assuming I was panicking. Preparation had been my power. Not anger. Not confrontation. Not a single moment of begging or threatening or making scenes. Just paper. Just records. Just dates and signatures and the quiet, steady habits of a woman who had spent her entire professional life making certain the right details were always in order. Calvin had believed that cutting off the money would leave me with nothing. What it actually did was give me the one thing I needed most, the chance to let the truth speak clearly, in the one place where truth is required to be heard. If you enjoyed this story, please take a moment to subscribe to the channel and share this video. And I'm curious, what would you have done in this situation? Would you have handled it the same way that I did? Tell me in the comments below. Thank you for watching, and don't forget to stay tuned for more stories like this.